We've called today's hearing in order to examine the Fraudulent Joinder Prevention Act. This is legislation aimed at addressing an obstacle to the removal of civil litigation from state court to federal court in diversity jurisdiction cases. And I want to thank Representative Ken Buck, a member of the Judiciary Committee, for introducing this legislation. Federal diversity jurisdiction exists when the plaintiff and the defendants to a lawsuit are from different states. According to the Supreme Court, the Constitution has presumed, whether rightly or wrongly, that state attachments, state prejudices, state jealousies, and state interests might sometimes obstruct or control the regular administration of justice, unquote. Thus, the Constitution's framers created diversity jurisdiction to preserve national harmony and promote interstate commerce by ensuring that a lawsuit involving citizens of different states could be litigated in a presumably neutral federal court rather than in a possibly biased state court. In general, under federal diversity jurisdiction, if a plaintiff from one state files a lawsuit against a defendant from another state in state court, the defendant may have that litigation moved from state court to federal court. However, for more than a century, plaintiffs have attempted to defeat removal in these cases by joining an in-state defendant with no real connection to the underlying claim. In response to these attempts to wrongfully deprive defendants of their right to have their cases heard in federal court, the Supreme Court developed the Fraudulent Joinder doctrine. But the Supreme Court has not clarified or elaborated on the doctrine since the early 1900s, nor has Congress stepped in to statutorily fill the void. This lack of guidance from the Supreme Court and Congress has led to poorly defined standards and inconsistent interpretations and application of the Fraudulent Joinder doctrine in the lower federal courts. For instance, if some federal judges require a showing that there is no possibility of recovery against a local defendant in order to keep the case in a federal court, others require an even more difficult showing that the claim be wholly substantial. That the claim be wholly insubstantial or frivolous. Still, other justices or judges insist that a defendant demonstrate that there is an obvious failure to a state claim against the defendant. All of these approaches and the others that are used are difficult to meet. In fact, current law is so heavily jaded against defendants that Federal Appeals Judge J. Harvey Wilkinson recently observed in support of congressional action to change the standards for joinder that, quote, "There's a problem with fraudulent jurisdiction law as it exists today, and that is that you have to establish that the joinder of a non-diverse defendant is totally ridiculous and that there's no possibility of ever recovering. That is a sham. That's corrupt. That's very hard to do. The problem is the bar is so terribly high," unquote. To make the law more fair, the Fraudulent Joinder Prevention Act makes a modest change to existing law to ensure that defendants who are entitled to a federal forum do not have their cases sent back to state court based on unreasonable or inconsistent standards. To accomplish this, the bill simply adds 2 additional sentences to the statute governing removal. Embodied in these sentences are 2 basic concepts. First, that federal courts should evaluate fraudulent joinder under one uniform standard, namely, whether the plaintiff states a, quote, plausible claim for relief against the non-diverse defendant, and second, that the federal courts are permitted to look at evidence submitted by both the plaintiff and the defendants in making this determination. This legislation will improve the administration of justice in the federal courts, and it will especially help small local businesses and their owners and employees who are currently unfairly pulled into costly lawsuits by trial lawyers simply to keep cases in state court. Small businesses are already overburdened by litigation as it is. They should not be further weighed down by cases to which they have no real connection simply so that an enterprising attorney can game the system. And I look forward to the witnesses' testimony and any comments and suggestions they may have with regard to this legislation. And now I would recognize the ranking member for his statement.